Of course, my lord, I agree that ideally there should be a uniform civil law. There should be. But the problem is that in the absence of that, there are today, my lord, almost 100 million Muslim women who are being discriminated with as a result of this Sharia application law, section 2 of the Sharia application law of 1937. It says that the Sharia law will apply regarding interstate succession. And unfortunately, my lord, under the Sharia law, Muslim women are discriminated against. They receive half or sometimes even less of what their male counterparts receive. And therefore, we are saying that this is discriminatory. This is violative of Article 14. And if your lordship strikes this down, then we are saying that your lordship can do either of. Last time your lordship's concern was that there will be a vacuum. What will happen? And what we have suggested is that either your lordship may say that the Indian Succession Act, where it says that it will not apply to Mohammedans, your lordship may read that down.
They cannot legislate. That
No,
is also amount to legislating.
No, Lord, it's a reading down for a specific purpose.
There is no reading down.
And your lordship has already held.
Reading down is
No, I know.
a higher bar being brought down. You are just asking us to delete a particular provision.
We are saying that in order, because my lord, what is the foundation of this challenge? The foundation is Article 14. We are saying that this provision fill up that vacuum in many ways. One way is what your lordship said in this tribal Chhattisgarh Ramcharan case, where your lordship said that, well, in the vacuum, you will apply equity, the principles of equity.
Just good conscience.
Yes, equity and good conscience. The other way is to say, well, whatever law is applied, it can't be discriminatory against women. The men and women have to be.
In that case,
yes,
the legislature was silent. So unoccupied field,
yes,
we observe justice, equity, good conscience. Here, the Shariat law exists.
So that we are challenging. We are saying that is discriminatory.
Shariat law should be held ultra vires.
So for the first time, my lord, your lordship will be examining that. The question is very simple. Prima facie, my lord, on the face of it, it is discriminatory to say that women will get half or even less than what their counterpart males will get by way of inheritance. Now, the question is whether this is an essential religious practice protected by Section 25. And in so many cases, my lord, your lordship has held, for example, in triple talaq, your lordship held that is not an essential religious practice. This certainly, my lord, is a purely civil matter. It can't be an essential religious practice protected under Article 25 of the Constitution.
That may not be a religious practice. That too.
Therefore,
testamentary is also important. Section 2, Section 3. Nobody. Testamentary is not essential religious practice because the act itself calls it out. It's an optional.
The prayers at page 80, the prayers. First is, my lord, first prayer is declare Section 2 of the Sharia Application Act 1937, insofar as it governs interstate succession, is unconstitutional and violative of 14, 15, 21, etc. Second is, declare that the rules of intestate and testamentary succession under Muslim personal law do not constitute essential religious practices under Article 25 and are subject to constitutional scrutiny. To my mind, my lord, it's an obvious proposition that this is a purely civil issue. The testament or the rights, inheritance rights of Muslim women certainly is not an essential.
Problem will be if, Mr. Bhushan, someone will argue
Yes.
that it's a question of personal law.
Yes. It may be a question of personal law, but it's not an essential religious practice protected under Article 25. And in the absence of that, my lord, it is certainly subject to Article 14. If it is subject to Article 14, then, my lord, it's prima facie, ex facie discriminatory. And if it is discriminatory, my lord, it needs to be struck down. Now the question is, what will happen? Whether there will be a vacuum, what will happen? If your lordship strikes down that and says that no, Sharia law will not apply, it can't be discriminatory, then one non-discriminatory law which can be applied is the Indian Succession Act, which is completely agnostic towards male and females. So, although, my lord, that law was meant to be applied to Christians, Parsis, etc.,
But there probably section 2 or expressly says it won't apply to.
yes, it does. It does say it will not apply to Muslims,
So
Hindus.
Unless that provision is struck down.
Yes, so we are effectively saying, my lord, that your lordship can strike it down in this also, because Hindu succession law is codified by the Hindu Succession Act. Only the Muslim succession law is not codified. That's the only law which is not codified, and it is subject. And if your lordship reads Mullah, the rules of succession under the Sharia law are so complicated that it is impossible even for lawyers to discern what is the succession practice under the Sharia law, etc. Therefore, at least this much needs to be done, that it can't be discriminatory between males and females.
Testamentary.
Either way, our criticism will be that we want to either legislate or
Ideally, I agree with you.
amend the existing law.
I have always maintained, my lord, and I have always told my Muslim friends also that don't oppose uniform civil code. Many of them, my lord, oppose uniform civil code because the fear is that in the name of a uniform civil code, the Hindu civil code will be imposed on them. This is the fear. So I have always said that civil law should be uniform for all, across all religions. Civil law should only...
Code is a constitutional declaration. Uniform civil code has nothing to do with any religion particularly. It's a constitutional ambition.
Yes, it's a constitutional ambition for good reason, because the civil law should be uniform in a country, irrespective of religion.
In fact, in a way, if you look at the personal law of marriage,
Yes,
the Special Marriage Act
yes.
is one of the steps towards uniformity in matrimony.
Yes.
That you have an option
And
to
unfortunately, my
opt
lord,
out from your personal law
yes,
and solemnize a marriage,
Yes.
as well as the rights of paternity and custody, etc.
yes, correct, my lord,
under the Special Marriage Act.
correct. Unfortunately,
And now also with the Juvenile Justice Act
yes,
permitting adoption,
yes.
so you make inroads into the personal law domain. But Mr. Bhushan, these have been legislative interdicts.
Yes.
They are legislative exercises. Will it be appropriate for the court to delve into these?
So that legislation, my lord, the
freedom
section...
of religion is a part of the fundamental rights.
No, freedom of religion is. But, my lord, the question is, if a religious practice is inherently discriminatory or against equity, good conscience, etc., which are lot
things, public order, morality,
etc. Therefore,
it's falls foul of neither of these three standards.
yes, so there, my lord, even if it's a religious practice, it has to be struck down, because the constitution, once the constitution comes, it does not permit any practice to be discriminatory, inherently discriminatory, unless, my lord, your lordship elevates it to the principle of an essential religious practice protected under Article 25. Until that happens, my lord, and I submit that certainly inheritance is not an essential religious practice protected under Article 25. Your lordship has held for so many things that these are not essential religious practices. For example, even praying in a mosque, your lordship has held is not an essential religious practice.
That we are examining now.
That's all right. There are several other cases which are similar or allied, which are pending before this court. For example, my lord, there is in this Safia PM versus Union of India, the question which is pending before. There are at least 3 cases which are allied, which are pending before this court. Naushad versus Union of India, Hurram Sunat Society versus Union of India. These are all allied issues, not exactly identical, but allied issues.
Discriminatory cannot be inherited, but it can.
And my lord, in Shabnam Hashmi, your lordship held that even the rights of adoption, and in Mary Roy also your lordship held that the Christian women in Travancore, there was a Travancore Act which discriminated against Christian women, and your lordship held that that act has to give way to the Indian Succession Act, and the Indian Succession Act, which is agnostic between men and women, will have to apply. So this is certainly, my lord, an important legal question which needs to be examined by this court, and it's arising actually directly for the first time before this court, though there are allied issues which are pending before this court. In Safia PM, my lord, which is pending before this court, the issue is whether a person born Muslim but no longer a believer can be compelled to be governed by the Muslim personal law in matters of inheritance and succession. In Naushad, my lord, the question is whether a Muslim individual can opt to be governed by the Indian Succession Act instead of Muslim personal law. These are all pending before this court. Quran Sunnat Society versus Union of India, the question is application of Muslim personal law in matters of inheritance and succession. Similar question, my lord. So these are pending before this court. But this matter needs to be examined by this.
Which matter is pending on the inheritance?
This is
Quran Sunnat Society.
Quran Sunnat Society versus Union of
It
India.
does not ask whether inheritance is an essential religious practice.
This was, no, that's all right, filed in 2016, but it is still pending. The other one, my lord, whether a Muslim individual can opt to be governed by the Indian Succession Act 1925 instead of Muslim personal law, this is also pending. This is Naushad versus notice was issued on 17th April last year, about a year ago.
Mr. Bhushan, at least instead of giving it, I mean, of course, public interest, PIL it can be because public interest element is there.
Yeah.
But always ideal in such like matters, some aggrieved person is also there.
No, in fact, my lord, the advocate on record is a Muslim woman, but
Man. And
man,
the petitioner Muslim.
and the petitioner, the second petitioner is a Muslim woman.
There is a foundation. Huh?
But I have actually, my lord, I saw after the last hearing of this case where your lordship heard the unamended petition, there was an avalanche of people who had
we
issued.
appreciate their effort. These two girls, I was just looking at who are the persons and.
Yes, yes. So this young lady, my lord, who has drafted.
We will take up it after 2-3 weeks. Meanwhile, just find out some who are the.
No, any number. Actually, my lord, there was a statement issued by a very large number of people
We've attached that.
supporting this petition.
We've attached that as annexure.
They will persuade someone to.
They had all supported this petition. Formally issued a statement.
Issued a press statement that we have attached as annexure. They've officially issued a press statement.
No, must be. There must be. People
Many people have issued one. A group's called Indian Muslim for Secular Democracy,
Irrespective of
the
the religion.
Bharatiya Muslim Mahila.
Irrespective of the religion or reason, you will find people are suffering from different kind of local issues, religious issues, state issues. There are victims always in a system. So if they formally on record comes forward,
Will.
No, that we can do. There is no, last time also I had said, my lord, I can bring any number of petitioners, Muslim women who can be petitioners in this case. If your lordship sees that statement, इसमें लगा हुआ है?
Letter.
On facts, if someone makes out that this is how they will.
ऊपर ही है, annexure 1 है.
Annexure 1. Letter that has been attached. लगा?
हाँ, ये annexure 1. Even the media was annexure 1.
Annexure 1 of the petition, my lord, is a letter which has been signed by so many Muslim women, men and women both. Page 89. This is the list of signatories. And my lord, the statement is on the earlier at page 86. It's a long press statement by Indian Muslims for Secular Democracy.
And the Bharatiya Muslim or Mahila.
And they say at the end,
The last.
IMSD supports at page 88 at the bottom, supports the ongoing Supreme Court proceedings and calls for a resolution that guarantees equal inheritance rights for Muslim women across India. We advocate for a solution that addresses gender discrimination in all personal laws, ensuring that women from all communities are treated as equal citizens entitled to dignity and justice under the law. I was saying, Lord, that though the Special Marriage Act is a proper codified law, in the Hindu Marriage Act, it says, unless custom otherwise permits. For example, marrying your first cousin. It is not permitted in North India, it is permitted in South India, in most places.
This one. And the court has never clarified that.
Law, even testamentary succession,
Permitted, not
you can't give more than 1/3. There is a big problem.
barring.
Your Lordship, if I could make a small point. Section 3 of the Shariat Application Act 1937 makes testamentary succession voluntary or an opt-in scheme in which you have to file a declaration to opt in. However, since there are no rules how to file a declaration, it is operated as a residuary law right now. Making 172 million Muslims, which is according to the 2011 census, completely incapable of willing away their own self-acquired property according to their own will. Testamentary succession is not an essential religious practice as it is in the act itself. If it was an essential religious practice, it would be part of the mandatory part. But it is not part of the mandatory part. It is an optional. The legislature itself carved it out. Yet, because of residual application, it is being applied, and every Muslim who has self-acquired property is being held to this 1/3 restriction without any proper statutory backing of the situation. This is also a very important question that needs to be considered.
Anyway, my lord, this is certainly a very important constitutional issue which needs to be considered and decided by this court.
Much obliged, Your Lordship.
Just give us the number of that
Yes,
2016 matter.
These are the three cases. The last one is the one which your lordship is referring to.
Should be also present. And meanwhile, us,
Much obliged, Your Lordship.
Yes, this one.
let's find out some actual sufferers.
Yes.
Because for the purpose of tomorrow, the issue of 25 will
I
also arise. The other issue will arise at least.
No, we will certainly get, my lord, a large number of Muslim women who have been denied equal rights and therefore who are aggrieved by this. So,
Denial is at least not a dispute.
Yes.
Denial will definitely there.
yes.
If your lordships permit me, your lordship, I can pass over a compilation of news reports of many women who have been denied. These are recent news reports from from Pulitzer institution, Outlook, etc. For
No,
lordships.
meanwhile, don't
I would
go to
also
that.
add this as amendment in the.
She has done a lot of work in this case.
Add them
Very.
as interveners or parties to the
Will do, your lordship. Will do.
so
All
that
right.
it does not appear to be a group of persons challenging personal faith,
Fair
but
enough,
a sort of reformation from within the faith.
Deeply understood.
We will do that. We will.
Much obliged, your lordships.
I understand, my lord, this is a sensitive matter.
Yes.
This will
That is why we want
raise
to-
a lot of hackles and sensitivities.
want to have the exercise of reformation, because what we are doing is catalyzing a reformation
Yes.
that should come from within the sect itself.
Ideally, yes. It should. The problem there is, as I was saying, Lord, even Hindu law is not uniform. Customs are different. So therefore, if they want to make a uniform civil code, they will have to go one way or the other. For example, whether you can marry your first cousin or not. There will have to be a uniform law. It can't be left to custom if there is a uniform law.
The answer is there in the constitution.
Pardon, my lord?
Answer is there in the constitution. The thing is,
Ah.
how much the society is ready to
Ideally. So, my lord, what needs to be done is that
Exactly.
for drafting the Uniform Civil Code, I have always maintained for drafting the Uniform Civil Code, my lord, one must incorporate the most liberal elements which are non-discriminatory from the various civil codes, etc., of different religions.
Idea is to develop a scientific, rational, humanistic temper as engrafted in the fundamental duties. But Mr. Bhushan,
Absolutely, my lord.
appreciate.
Unfortunately, we are going the opposite direction.
I don't know where
Instead
we are,
of-
but
instead of-
we are acutely conscious of our limitations as a constitutional entity to preserve constitution. But is it within the scope, ambit, and ability of judiciary to make social reforms?
So it's not that, my lord. It is within the scope, ambit of the judiciary to strike down discriminatory provisions. That is certainly. Now,
Discriminatory laws.
discriminatory laws or discriminatory provisions in
Yes,
various
yes.
laws. So that is certainly within the remit of the judiciary. But of course, ideally, as I said, ideally there should be a uniform civil code, but it should not become, as my lord, Muslims fear. Muslims fear is that it will become de facto the Hindu civil code, which will be imposed, though the Hindu civil code is also not uniform. It is not uniform because it is dependent upon custom. So even that is not uniform. So ideally, it should be combining the most liberal elements, which are non-discriminatory, and I am obliged.
Permission to add petitioners or
Go ahead. We will add the petitioner. Your lordship may permit us to add.
You can always, as intervener, they can.
Yes, yes.